practice?
From what I heard, I wasn't sure.
Let me go check. Ms. Walk and De Leon.
Well, honestly.
No, we're not walking. We have Ted Liu.
Ted Liu and De Leon. As soon as you get, we can't adopt the rules until we have a
We
quorum.
have to have quorum first.
What, 2 more votes?
Good afternoon, Mr. Chair.
That's good enough.
Gentlemen, welcome. Grab a seat. Madam Secretary, if you can call the roll to establish a quorum.
Correa?
Here.
Correa here. Lamalfa? Lamalfa here. De Leon? Gaines? Gaines here. Liu? Here. Liu here.
We've established a quorum. The first order of business today is to adopt the rules of the committee.
Correa?
Aye.
Correa, aye. Lamalfa?
Rules of the committees.
Lamalfa, aye. De Leon? Gaines?
Aye.
Gaines, aye. Liu?
Aye.
Liu, aye.
The rules of the committee have been adopted in a 4-0 vote. We can move then on to our order of business today. Our first item, Senate Bill 168 by Ms. Corbett. Welcome, Ms. Corbett. You may begin.
Thank you very much, Mr. Chair and members. I'm here to present Senate Bill 168. This is a measure which I hope will help us deal with issues of fraud in the collection of signatures for petitions. Senate Bill, first of all, let me just say this because I've been reading the various blogs. This measure does not prevent the ability for signature gatherers to be paid to collect signatures for petitions. I just want to make that clear. However, it would prohibit signature gatherers by being paid on a per signature basis. And this is to reduce the incentive of misleading the voters in the collection of fraudulent signatures. It doesn't prohibit payment by salary or hourly wage, just by per signature basis. California's initiative process, as many of us know, began back in 1911, and the goal was to put legislative power back into the hands of the voters. It was a major reform measure back then. Since the 1990s, Californians have witnessed a considerable increase in the number and complexity of initiatives introduced by this process, and along with that, unfortunately, an increase in election fraud. The initiative process is a very important tool for California voters who want to have their voices heard. Through grassroots efforts, individuals and local groups have the opportunity to participate in direct democracy through this process. And the intent of this bill is not to restrict a voter's ability to place an initiative on the ballot or to prohibit compensation for signature gathering, but rather to eliminate a perverse incentive that encourages collecting and submitting fraudulent signatures. I'm sure many of us have had the opportunity to meet a signature gatherer from time to time, and I know that I have seen false statements made about the actual provisions of an initiative in order to try to ask that I sign a particular ballot measure, and I'm sure you've all seen that as well. Hopefully this would stop that practice. Senate Bill 168 is supported by the Secretary of State's office and the City of Murrieta and the county of Contra Costa County. And here to testify in support is the Secretary of State's office, and I believe the City of Murrieta might be being with it.
Witnesses in support. But before you do that, I just want to say we have the last opposition letter from the Humane Society to your measure.
Yes, we didn't receive any opposition till I believe yesterday, so it's late opposition, and I am aware of that. Thank you.
Witnesses in support.
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen in strong support of this measure. As Senator Corbett indicated, we believe by taking away the ability to pay a signature gatherer per signature takes away that incentive for them to mislead voters, and we hope will take away the potential for fraudulent signature gathering practices. So with that, I'd be happy to answer any questions and respectfully urge the committee's support.
Others in support.
Mr. Chair, members, Hugh Bauer on behalf of the City of Murrieta. And, unfortunately, during the last election cycle, the City of Murrieta was a focus. They're focused on a number of local initiatives, and unfortunately, there were a number of documented instances of petitioners who were misleading voters. And so Murrieta is fully in support of the initiative process and the circulation of honest petitions. However, we would argue that, as the Secretary of State and the author have noted, that the paid signature technique does create an incentive for malfeasance, and so therefore we stand in support.
Others in support? In opposition?
Thank you. You're welcome.
Opposition?
Sure. Hi, my name is Jennifer Fearing. I'm with the Humane Society of the United States, and we very much enjoy working with Senator Corbett on a lot of legislation. Really appreciate your involvement, in particular with the Animal Protection Caucus, and regret that we disagree with this pursuit, this way of addressing the stated problem. I was the campaign manager for the Proposition 2 campaign in 2008, so I do have some personal experience, and we have 20-plus years of experience sort of in initiative work in other states that sort of informs our concerns today. And just for the record, the way that we do campaigns is fundamentally probably very in line with the original intent of initiatives, and very much different from the way a lot of folks utilize it these day and age. In 2008, we had 4,000 volunteers collect 500,000 of the signatures that put Prop 2 on the ballot. Even with that significant amount of grassroots engagement, which is unheard of really in modern day initiative work in California, we still had to pay close to $400,000 for additional signatures, and every one of those dollars was hard for us to part with, as a group that has limited resources and a nonprofit status. Our concern here is that, and it's been stipulated in the various litigation in other states, some of which federal courts have overturned these type of approaches, is that it's been stipulated that the costs will definitely increase. The costs associated with this pursuit will be higher, and its ranges from 6 to 100% have been the ranges of cost. So our concern is that there will be disproportionate harm to grassroots grassroots groups like ours. Companies and other interests which can afford, who really have an interest in seeking an initiative, aren't going to be deterred by an extra zero. Grassroots groups will absolutely be deterred, and we're concerned that you may inadvertently discourage the very kinds of activity that if one likes the initiative system, you're discouraging the kinds of players who utilize it in the right way. So we're concerned, some other concerns, but I just want to highlight a comment made in the recent Colorado decision blocking enforcement of a much weaker restriction, which just banned more than 20% of circulator pay coming from a per signature basis. And the judge said that pay per signature compensation is no more likely than pay per hour compensation to induce fraudulent signature gathering or increase validity rates. So we would like very much to work with the senator to perhaps identify a way to address the fraud issue, maybe with more of a scalpel than a shotgun, so that organizations like ours aren't precluded from utilizing the process.
Thank you.
Thanks.
Other opposition?
Hi, I'm Richard Winger with the Coalition for Free and Open Elections. She stole some of my lines. The Colorado case was in 2010, and the judge listened to an awful lot of expert testimony, and the witness who seemed most influential was a political scientist who's actually gone across the country and looked at petitions, used his own techniques for uncovering fraud. And he said, in response to a question from the state, Dr. Smith, in your opinion, does paying signature gatherers by the signature incentivize them to commit fraud? And he said no. There was also a case in Ohio which had the same result. The case was thrown out not only in U.S. District Court, and the judge was a Clinton appointee, but by the Sixth Circuit. And then Ohio asked for U.S. Supreme Court review, and they said no. And the Sixth Circuit said there is little dispute that operating under a per-time-only system will increase the cost of both proposing an initiative and qualifying it for the ballot. And finally, the analysis here mentions the Ninth Circuit decision in Oregon in 2006. But the Oregon law, first of all, the Ninth Circuit didn't uphold it. They said, we express no opinion, however, regarding whether Measure 26 could withstand strict scrutiny had plaintiffs proven the measure imposes a severe burden. The people rushed into court right after it was passed, before there had been any experience with it. They presented no evidence. Also, in the Oregon law permitted organizers to establish either express or implied minimum signature requirements for circulators. It permitted them to terminate circulators who do not meet the productivity requirements. It permitted them to adjust salaries prospectively and pay discretionary bonuses. This bill here doesn't do any of those things, and I think all those things would be illegal because it says paying them per signature directly or indirectly is illegal. So I think it's very badly written to withstand court challenge.
Thank you. Other opposition?
My name is David Kaiserman with National Voter Outreach. Thank you. Yes, ma'am. Again, my name is David Kaiserman with National Voter Outreach. We are a nationwide petition signature gathering firm. There are 26 states that allow the initiative petition, and in the last 25 years, we have done business in each and every one of those states, certainly including California. I'm here to talk about the F word. Maybe that'll get everyone's attention here after lunch. The F word, of course, being fraud. I am faced out on the street with this word every single day. And from the time we start a campaign, we emphasize to each and every person involved that the F word allegation can kill this campaign. Now, there has been a study done. Is the F word overused? Let me kind of throw out some facts here. Over a 10-year period, they analyzed over 81 million signatures that had been submitted and verified with the 26 Secretary of States around the nation. Now, that doesn't include the signatures that they reached their threshold and quit. That doesn't include the signatures that were thrown out because they lacked required information. 81 million signatures over a 10-year period. There are 17 instances of fraud from the states that responded. Let's go back here. Out of 26 states, each one of the states, they submitted Freedom of Information Acts to the Secretary of State's Attorney Generals requesting any information concerning prosecution for fraud in initiative petitions. 20 of them fully responded. California did not fully respond. California said there are cases of fraud that are being investigated, and I'll come to that. But I want to paint this big picture on what we're trying to accomplish here today. 17 instances of fraud. That is one instance of fraud per 4.7 million signatures collected. I submit, if we were talking about any other criminal activity, if you were to ask a state, of your drivers, how many have committed a traffic infraction, and a state could cheer and say 1 out of 4.7, what an overwhelming success. So that is contacts, one instance out of every 4.7 million voter contacts. And those are conservative numbers. Now, let's look at the states where the fraud was occurring. By the way, there are 8 states out of the 26 that have passed restrictions identical to what is before this committee. Of the 8 states, 6 have already been overturned by the federal courts and federal appellate courts. 6 out of the 8. Of those states, of the 26 states, who has the most instances of fraud? Let's see, Ohio used to restrict, until it was overturned, pay by the signature. And North Dakota, who still has a restriction on payment by signature. Those were the 2 leading states that showed instances of fraud. Now, let's move to California, and I'm going by the staff's comments.
I just wanted to mention that the witness who is here in opposition did not stop by my office or send any letter. I'm just letting you know that. This is the first I've heard from him. I just thought that was important to know.
And Senator, I sincerely apologize.
I need you to
That's
finish
okay,
your
just
testimony
finish
because I gotta
Just make it.
go into business, so go ahead and make your points, and you guys can address your issues later on.
Well, I certainly didn't mean to violate any protocol with the senator of this committee.
Go ahead, sir.
Okay. I'll just sum it up. If we are here to eliminate fraud, to police fraud, I will spend hours upon end, because when we run a campaign, I want a squeaky clean campaign. And I do have suggestions, because I spend 18 hours a day out on the street involved in this and making sure fraud does not occur.
Thank you very much. Other witnesses in opposition?
My name is Dave Kadlacek. I'm have many hats, but for this, the relevant things, I guess, are being on a tenant activist in Oakland and being on the State Board of Californians for Electoral Reform. One of the arguments that was made in talking about fraud was about misleading and false arguments made by signature gatherers. I think it's clear that that's not just a matter related to...
Ms. Corbett, if I can ask you, discuss that a little later on. I'm trying to hear.
I think it's clear that problem. One is that what's a misleading or false argument depends on who's listening to it, and opponents of something may say something's false or misleading when proponents would say it's true and fair, and that's when we heard talk of fraud. I actually, in relation to this, I actually thought this was referring to things such as signing people who you knew were not valid signers onto a petition and things like that, not things having to do with the arguments made to convince people to sign things.
Let me ask Ms. Corbett, which kind of fraud are you referring to? That
I'm referring to that kind of fraud to assure that we don't have people signing, that we don't have an incentive for people to collect signatures on a paid signature basis, because it could also lead to the fraud of having false signatures, as well as the concern about false statements about the initiatives. Both.
So that's what you're addressing. Okay,
yeah, both.
Thank you.
But it's what's
fraud for that
misleading statements are in the eye of the holder and ought to be and if there's a problem with that, that should be dealt with directly and not through disincentivizing that. And you look at the same sort of thing applies to arguments once something gets on the ballot.
How do you deal with that?
Favor.
What's a direct manner of dealing with misleading statements?
I don't have a clear answer for that.
I don't have that answer either. I know when I'm at the supermarket and somebody's trying to get my signature, I'm pretty astounded of the statements that are made to me as to why they need my signature. But that's not really the issue you're really focusing on here, is it, Ms. Corbett?
It's the issue of an incentive to collect as many signatures as possible, because one is paid
so
per
then
signature.
This bill does not address what statements are made at the supermarket to gather signature.
No, not specifically.
It addresses the incentive.
Strictly outlaws the practice of paying on a per signature basis. Does not prohibit paying circulators for collecting signatures, but only on a per signature basis to deal with that perverse incentive of trying to get as many signatures as possible at all costs.
Sir, if I may, I'm going to ask you to go ahead and conclude. I didn't mean to interrupt you, but go ahead and make your points.
Yeah. So the reason I mentioned being a tenant activist in Oakland was because I had been very involved in the campaign. I forget whether it was 7 years ago or 9 years ago to get an initiative measure on the ballot to require just cause for evictions in Oakland. That was done mostly, but not entirely, through volunteer signature gatherers. But at the end, the campaign needed to pay some signature gatherers to get the last few signatures over the top. And I would maintain that the real problem with using paid signature gatherers is that it's too hard to qualify measures for the ballot. There's special provisions for San Francisco as a city and county, and in a few chartered cities or cities and counties charters that make it easier. And in those places, it's feasible to qualify measures for the ballot by volunteers. But the long time period, together with the number of signatures required for state initiatives and for local initiative in places that follow the general law, makes it so difficult that it's almost impossible to qualify something except by paying signature gatherers. And incentive, if your intention really is to get something on the ballot, all of the incentives to mislead or whatever apply to volunteers who really want to get something on the ballot just as much as they would apply to someone paid for by signature. So I would suggest you look into making it easier to qualify initiative measures and such for the ballot. That's something. The last thing I wanted to make is just a reference, is that there's a lot of interesting discussions about direct democracy and initiatives and so forth in the recent book, California Crack-Up, by Mark Paul and Joe Matthews. And if you haven't already read it, I suggest you look at it and consider some of the arguments they have in there about indirect initiatives and other such things.
Thank you very much. Any other opposition? Seeing none, I'll bring it back to the committee. Any questions? Yes, Mr. LaMalfa.
Thank you, Mr. Chairman. Well, certainly, Senator, I understand the angst with which probably drives you to do this bill and the types of unattractive process we've seen across the state over the years. But the direction I would come from on this is that, the direct democracy is a very precious thing we have in this state. And so many times that the time frame you have in order to qualify, whether it's a referendum especially, or initiative, is pretty tight. And so a person that's a proponent of any type, and I don't care what the politics are, either side of an aisle, what have you, they need that opportunity. And indeed, it is grassroots at its finest, I think, in most cases. And so I wonder how would you address that the incentive process for people to gather signatures, rather quickly? How would there be incentive for someone to do it on an hourly basis or on a salaried basis and still get the kind of results? I mean, a lot of work in California is done per piece. In agriculture, it might be on what you bring in, trucking-wise or picking-wise or what have you, on the per-piece basis, which is an ultimate incentive. So please.
Well, first of all, Senator LaMalfa, I just want to address the additional point you raised in your comments. The reason that I believe that this is an important bill and the reason that I'm carrying it this year is I very much believe in grassroots, and I very much believe in the ability for citizens to be able to petition their government. You've seen the way I operate around here and the way I conduct myself in hearings. I think all of the comments that we hear from the public on all of the matters that we deal with in government are extremely important. And this ability that was placed in law back in 1911 to allow the people to petition their government and bring actions on their own it's crucially important. And I want to preserve and I want to protect that. That's why I'm carrying this measure. I don't want people to stop signing these petitions because they feel that someone just wants to get the money, or there's some sort of perverse incentive for collecting that signature. I don't want to see this way of government, this grassroots form of government. I don't want to see it collapse because we have concerns about fraud or people who are collecting signatures and maybe not being so sure about whether they're accurate signatures, but they're just more sure about how many they're going to collect so they can be paid. So I believe you can preserve it in the way that it is done in other states, where collection by signature, payment by signature has been outlawed. And other states do have successful programs and put measures on the ballot when people are paid on an hourly basis. So if you pay a person on an hourly basis, they can collect signatures as well. They can stand outside the grocery store and be persuasive, and do it the good old-fashioned way, by telling the facts and trying to convince the person that this is a good thing for them to sign. And that's really what I think was contemplated when this law was placed on the books back in 1911. So I do believe that the process can be protected, preserved, and people can have trust in this type of process with signature gatherers who are paid but not on a per-signature basis. And I believe the Secretary of State's office might have a comment as well. Our Secretary of State, Deborah Bowen, also wrote a letter, and I would just quote from 2 sentences from her letter that says, paying signature gatherers by signature may create an incentive to lie or mislead voters as to what they are really signing. Therefore, this measure has the potential to decrease fraudulent signature gathering practices. And I know she's very concerned about protecting grassroots governance as well.
And if I could, Mr. Chair.
Very briefly.
Quickly. I just wanted to clarify.
Unless Mr. LaMalfa needs additional explanation.
No, I'd like to hear her comment and then return to a previous thought, too.
I just wanted to clarify for the committee, based on the gentleman's previous testimony, just to be clear in terms of cases that have been opened in California. Since 1994, which is as far as the data goes back at the Secretary of State's office in our Elections Fraud Investigations Unit, there have been 240 cases on falsified petitions that have been opened. Of those, 46 of them have been referred to DA's office. Our office does not possess the enforcement authority to prosecute on our own. We refer those to other law enforcement entities to do the prosecution, and it has resulted in a total of 33 convictions. Of those, there were 16 cases opened just as recently as 2010, 4 of those being referred to the DA's office. So I just wanted to provide that information to the committee.
Thank you, Mr. Liu. You had some comments.
Oh, can I follow up, Mr. Chairman?
Go ahead.
Okay, thank you. I just to address, it's a little bit funny to me that we're getting after people and making false statements on gathering, but in the election process themselves, candidates are some of the worst offenders on putting out false information in campaigns. So I don't know that we can cast any first stones as a collective group here. But I'm really, though, I come back to my concern that if the grassroots doesn't have this incentive system here, and in many cases, most cases, it works well. I mean, it depends on the integrity of the campaign that's being run as to how they do that. You'll see that most signature gathering campaigns are getting about 70% valid or better, and that the incidences of actual fraudulent ones are very small. I think we step a little too far in the direction of punishing a few and taking away the true grassroots nature of what we're after. Because if you don't have people incentivized to gather signatures, hustling for them legally, as opposed to by hour, then the cost does go up, and that really eliminates, I think, a lot of true grassroots efforts, and it leaves it up to more of the fat cats that can write, big checks and herds of gatherers, especially in the compacted time period. So, if you're interested, I would be much inclined to team up with you in an area to go after and prosecute to a much greater extent those that are indeed committing fraud, that are lying about this, and make them have the fear of true retribution for doing so, and raise the penalties, raise the prison time, whatever it would be, scare the heck out of them from doing it. Because if they're caught doing it, and it's going to be pretty blatant when you find false signatures, some of the others are a little more vague perhaps, but we need not be putting up with this. But I'm very, very careful about taking away that the purity of the people being able to speak, especially at a grassroots level, instead of not having massive amounts of corporate dollars or other entities that can come in and fund this on a basis where they don't care how many signatures they're getting per day, per hour in a compacted time. So I'd love to work with you in a different direction on that, but I can't support what's going right now.
May I respond, Mr. Chair?
I would rather have Mr. Liu ask another question.
Sure.
Do that in my close then.
Please, go ahead.
Thank you, Senator Gordon, for bringing this bill and trying to reduce fraud. I'm going to vote yes on this bill and allow you to take it through the process. Let me just say what my concern is. If the bill as written were law, let's say 5 years ago, it would not have stopped, Prop 23 or the business interests that put on that Proposition Rollback environmental laws. But it may have stopped the Humane Society from putting up their proposition. And so if, when it gets to the floor, it becomes evident that it has a disparate impact on grassroots organizations, then I may reconsider my vote. So that's my concern.
Fair enough. Thank you.
Other questions? Yes, Mr. Gaines.
I've got a question in terms of the constitutionality of this, in terms of restricting political expression. And have you looked at that closely in terms of
yes,
limiting someone's ability of free
speech? As the former chair of the Judiciary Committee, yes, I did.
Okay. It seems to me that there is, I think, a self-regulatory aspect of this, too. If I'm going to pay someone to gather signatures on a per-signature basis, I'm going to want to make sure that those are, verifiable signatures. And I know that a lot of entities that are working on referendums or initiatives are making sure that they're not paying for something that's not legitimate. And so I question as to whether it's really necessary for us to move forward with this.
Thank you, Senator Gaines.
Thank you.
Other questions, comments from the committee? What's the will of the committee?
I'll move the bill.
We have a motion to move the bill for you. Madam Secretary, go ahead and call.
May I close, please? I know you want to get this done.
Go ahead.
But I just wanted to respond to the comments.
Go ahead.
Senator Lamalfa, I'm glad to sit down with you and talk about the issue of fraud. It's a huge concern of mine. I do, however, believe that this bill will still allow the grassroots process to move forward, and I think you know me. I wouldn't be here without grassroots. So that's why I continue to move this forward. And thank you, Senator Gaines, also for your concerns as well. I did look at the free speech issue. That's also extremely important to me as well. I just wanted to point out also to the chair and the other members of the committee that I'm glad to talk to others who have come in opposition today. It's always very, very difficult to respond when you don't hear the opposition in advance and you hear it at the day of the hearing, and I think it's only fair for that opposition to come forward so you have an opportunity to discuss this issue. So I'm glad to sit down with those who are in opposition today and see if we can speak to any of their concerns, and I do ask for your aye vote.
Thank you. Let me say that just very quickly, as before we vote, my perspective is that I do also believe direct democracy is very important. We should do everything we can to encourage direct democracy. And voting on this bill, I agree with some of the comments made by Mr. Lamalfa, yet from my personal experience, I have to tell you, in my district, I've had a lot of problems with this issue. Usually the way it manifests itself is person doing a voter registration along with gathering signatures for initiative. And the problems, I just personally, my primary in 2006, people getting flipped from D to R. And then along with that, people having signatures on these initiatives for totally unrelated reasons. And a lot of these people are not citizens. Then they'd come up to me, and I'd call them and say, why haven't you voted? Because they didn't register. Yes, you did. Well, no, I didn't. And the confusion it causes. You know, Mr. Lamalfa, I agree with you. You know, when you go up to the guy at the supermarket and they ask for a signature, and, for example, we had that initiative to cut our pay by 50%. I asked one of the signature gatherers, why do you want to do this? Because they don't deserve it. Okay, fair enough. But there's others that say sign here, but they don't tell you to gather a signature for an initiative or a petition. It's sign here for something else. That is a fraud that I'm after, and I'm going to have to vote yes on this because of my own personal experience, and hope you can work, Ms. Corbett, with the opposition and get down to something that maybe can alleviate the opposition. Madam Secretary, I guess this is a due pass to public safety. Please call the roll.
Correa?
Aye.
Correa, aye. Lamalfa? No. Lamalfa, no. De Leon? Gaines?
No.
Gaines, no. Liu?
Aye.
Liu, aye.
You have two, and you need one more. So we'll place that
Thank you
measure
very much,
on
members.
call. Next is Mr. Blakesley. Welcome. Come on up. You may begin, sir. Welcome.
Thank you, Senator. Thank you, Chair. Appreciate the opportunity, committee, to present this bill, which allows and directs the state of California to pay its obligations to those counties that, in good faith, follow the direction of the governor in the past few years to hold a number of special elections. As we know, due to term limits, vagaries of people's health and longevity, and other reasons for people leaving office, there have been upwards of 23 special elections in the past couple of years. And those special elections have not been reimbursed, which has put upwards of 26 counties in a position of having very significant debts on their books that
Mr. Chairman, may I move the bill?
Needs to pay. Historically, this obligation of the state was handled automatically. The legislation which handled it automatically sunset at January 1st of 2008, which makes this piece of legislation necessary. Virtually all of us, I think, probably have counties that are dealing with these unpaid bills, and this is just an opportunity to address this issue with the governor.
Witnesses in support and opposition, I'm going to ask you to, highlight the important points and try to be as brief as possible.
You betcha, Mr. Chairman. Paul Yoder, Shaw Yoder, Antwi, and Peterson Consulting. San Luis Obispo County is the sponsor of the bill, but other counties that we represent vitally need this bill. The cost of these elections are really adding up. I'll just put it that way. Thank you, Senator LaMalfa, for moving the bill, and I would urge an aye vote.
Thank you. Others in support?
Thank you, Mr. Chair and members. Kathy Christian, representing the Contra Costa County Board of Supervisors. One election in the 10th Congressional District and $1 million bill, unreimbursed bill. We urge your support. Thank you.
Others in support?
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen, also in support for the reasons already stated.
Thank you.
Mr. Chair, members, Jean Hurst on behalf of the California State Association of Counties, also in support.
Thank you.
Joanna Voris with the Urban Counties Caucus, also in strong support of the bill. Thank you.
Thank you. Very nice.
Robin Boyer from Monterey County. We want to thank Mr. Blakesley, and we are in support of the bill.
Thank you.
Tim Lynch on behalf of the San Bernardino County Board of Supervisors, supporting.
Thank you.
Jill Levine, I'm representing the California Association of Clerks and Election Officials, and we support your bill. Thank you.
Thank you.
Mr. Chair and members, Brian Langone on behalf of the Orange County Board of Supervisors in support.
Thank you.
Mr. Chair and members, Leslie McFadden on behalf of the Sacramento County Board of Supervisors in strong support.
Mr. Chair and members, Monica Miller on behalf of the County of Santa Barbara in support. Thank you.
Thank you, Ms. Miller.
Michael Radigan on behalf of the Board of Supervisors of Santa Clara County here in support.
Thank you.
And Mr. Chairman, members, Paul Smith with the Regional Council of Rural Counties, representing 30 rural counties in strong support of the measure.
Opposition to the measure? Seeing none, we have a motion. This is a due pass to appropriations. Madam Secretary, please call the roll.
Correa?
Aye.
Correa, aye. LaMalfa? Aye. LaMalfa, aye. De Leon? Gaines?
Aye.
Gaines, aye. Liu?
Aye.
Liu, aye.
The bill passes. We'll keep it on call to get additional members who may want to add for that vote.
Thank you,
Congratulations,
Chair. Thank you, members, and I'll just use this moment to lend my support to Mr. Price's bill, who's right behind me, who will make sure this doesn't happen again.
How about SB 199? Would you support that one? Sam, that's the old AB 773. The one that the governor vetoed, your bill, man. Come on, guy. Mr. Price, welcome. Come on up. Mr. Price, welcome.
Thank you, sir. Mr. Chair, members.
Yes, sir.
May I?
Please.
Today I'm presenting SB 141, which would require the state to reimburse counties for expenses incurred in special elections proclaimed by the governor to fill state or federal legislative vacancies. This measure is similar to AB 119, a bill that I authored in 2007 that was approved by this committee and signed by the governor. Unfortunately, the provisions of AB 119, which required the state to reimburse counties for special vacancy elections, sunsetted January the 1st, 2008, as Senator Blakesley referenced. Since 2008, there have been numerous legislative measures requesting authorization for reimbursement. I'm reintroducing this measure because special elections add considerable general fund expenditures to local government budgets.
Move the bill.
Usually these elections are unexpected and cannot be anticipated far enough in advance. And I respectfully ask for your aye vote.
Witnesses in support, please.
I have two. Where are we? Okay. I have with me the sponsor of the bill, L.A. County Registrar.
And a bunch of support right behind you.
A bunch of support. And I'd like to invite you and others to co-author this legislation if you're so inclined.
Witnesses in support.
Mr. Chair, members of the committee, thanks for the opportunity to be here. I'm Dean Logan, the Registrar Recorder County Clerk for Los Angeles County. I've submitted written testimony that mirrors the previous bill. We thank Senator Price for his support and urge the committee to support this bill.
Others in support.
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen, also in support for the reasons previously stated.
Others in support, please.
Monterey County is consistent in their support of any and all bills that will reimburse their expenses for elections.
Big money, okay.
Mr. Chair, Kathy Christian, San Diego County Board of Supervisors in support. Thank you.
Mr. Chair, members, Julian DeVos with the Urban Counties Caucus in strong support.
Back again, Leslie McFadden, Sacramento County Board of Supervisors in strong support. Thank you.
Jean Hurst with the California State Association of Counties also in support.
Brian Lundgren on behalf of the Orange County Board of Supervisors and the San Bernardino County Board of Supervisors in support.
Others in support.
Michael Radigan on behalf of the Board of Supervisors, Santa Clara County, here in support.
I'm Jill Levine. I'm the Registrar of Sacramento County, representing the California Associations of Clerk and Election Officials in support of this bill. Thank you.
Mr. Chairman, once again, Paul Smith, Regional Counsel, Rural Counties, on behalf of 30 boards of supervisors in strong support of the measure.
Mr. Chairman, other members, Paul Yoder, Peterson Consulting, Schuyler, Antwi, on behalf of our counties in support of the bill.
Mr. Chair and members, Monica Miller on behalf of the County of Santa Barbara in support of the bill. Thank you.
Opposition? Seeing none, would you like to close?
I think this is a responsible measure. I appreciate your support and invite any co-authorships.
You got a co-author. Any other co-authors?
Please add me as a co-author, and thank you for bringing this forward so that we can properly pay the bills that the state owes.
I'll jump on as your co-author, too.
Thank you.
I will, too.
Madam Secretary, this is moved this to...
Ted, good. Ted and Ted.
Darren.
To appropriations?
To amend, to add the co-authors.
Yeah, we'll come up.
Okay, so it's a do pass, amend to appropriate.
Do pass to amend to appropriations. Please call the roll.
Correa?
Aye.
Correa, aye. Lamalfa?
Aye.
Lamalfa, aye. De Leon? Gaines?
Aye.
Gaines, aye. Lou?
Aye.
Lou, aye.
That measure passes. We'll keep the roll open for others to add on. I got Mr. Yee. Mr. Yee, is he on? If not, I'll jump on and present my bills, I think. Yes?
He said he was watching on TV and he was coming down.
Well, let me present. He's right here?
He's walking down.
I'll do it. I knew that would get him here. Welcome. Come on in, Mr. Yee. Jump on.
Thank you very much, Mr. Chair.
Go ahead.
SB 88 is a rather straightforward bill. The context of this is that as we are finding more and more candidates understanding the importance of reaching out to a variety of different communities, particularly in the Asian community, there have been efforts and there have been actual attempts to try and advantage a particular candidate towards the Asian community. And the way in which that has happened is that candidates not from the Asian community normally would not have Asian names. And so in the course of running for office, you want to have an Asian name that may suggest that you are a person of tremendous quality, and you may not. But by translating or creating a name for yourself that has that meaning would advantage a particular candidate. What this bill will do is to set in place a procedure whereby you go ahead and identify yourself with a particular name, and you can use that name so long as it's been in the public domain for the last 2 years. If not, then the only name that you can have is a transliteration. And that's all this bill does. It is an opt-in. It is not a mandatory requirement for those particular counties that want to, I think, protect the integrity of a vote. You ought to opt into this particular program. This bill just simply sets the procedure as how you would then, in fact, opt in. So with that urgent, I vote.
Witnesses in support.
Janus Norman on behalf of the American Federation of State, County, Municipal Employees. We have a growing segment of our labor union that is, in fact, from the Asian community. And as we have have done outreach internally within our union, and as our union has gone out into the community, we have found that this is a growing problem, and so we appreciate the senator's efforts to sort of correct it, to make sure that people aren't selecting names that would bring them an undue advantage in elections. We appreciate his efforts.
Opposition.
Good afternoon. This is Jill Levine, Registrar of Voters of Sacramento County. I'm representing the California Association of Clerks and Election Officials. And while in concept we do support this bill, we have problems with one section, and we have spoken or written a letter to the author. And it's the section concerning the local appeal process. Since this is there's already a method in place that would not prohibit this, we would prefer going basically to the courts. And a couple of this is putting another layer of government into the county, and the other issue is also if a candidate was running, let's say, for a statewide office, we would like to make sure that one county didn't say one thing and one county didn't say another. We wanted to make sure it came through the court system. So I think we can work. Thank you.
You think you can work?
We think we can work with the author on this.
Okay.
Hopefully.
Others opposition? Will of the committee? Mr. LaMalfa? Of course.
Okay. Senator, the lady brings up a point I was kind of wondering about too, in that do you intend for this to be on a countywide or citywide basis or statewide? Would you see a translation of a candidate's name intended on a statewide ballot, or an entire assembly or senate district, or particular zones? How does that work?
Well, initially we did have a bill last year that basically would be a statewide requirement. I think that there were a number of counties that said that we don't feel that this is an issue within our own county. And so what we did was then we amended the bill in the assembly to make it an opt-in situation. So it's really county by county. So that's that's a way in which this bill would then operate. That within a particular county, if you so desire to establish these particular procedures, then you would then make that applicable to elections within your own county. Now, if it turns out that a particular candidate does not wish to have a, let's say, Chinese name, there's no requirement that you have a Chinese name. What has happened is that there are a number of candidates who now feel that it is to their advantage to go and reach into a particular election, a voter base, and have a Chinese name because maybe it's a little bit more appealable. But the problem has been is a situation whereby individual candidates may then create a name just for the convenience of that election that would somehow suggest certain kinds of favorable qualities, hoping that that type of translation will elicit support from that particular community. So that maybe a candidate will say that their Chinese name translated means the most ethical person in the world. Mm-hmm. And that is rather appealing to any voter base, particularly a Chinese voter base. And when that quality has nothing to do with that particular individual, and it was all because that individual was running for office and wanting to advantage him or herself towards a particular voter base. And that's what this bill tries to correct.
What if you have a European name? And what's the process for? Would it be more phonetic or more like by sounds or something like that? That would. Because I was thinking about running for mayor of a large city. It's accessed by two bridges, and I wondered how my Chinese name.
I think that a person who would say that I'm a famous rice farmer would advantage that person towards a community. But let me just say, if it turns out that that person had not used that particular set of characters in the public domain for the last 2 years, then the way in which we would handle that particular candidate's interest in a Chinese name would be just merely a transliteration, and that's how we would handle that.
Okay, so it'd be a straight across of either letter by letter or sound.
Sound, right?
Yeah. Okay. All right. I appreciate that. Thank you. I won't be running for any mayor thing.
I've thought about maybe changing my name, but I can't because you have to have already a name within the last within 2 years. So
what would you change it to?
I think a great rice farmer may not be too bad.
Mr. Liu.
I support the bill. I just had a question. Does it apply to candidates that span different counties or to statewide candidates?
Well, if a particular county, I think the point that has been made is, well, what if you have split county? I would imagine that what would happen is that, if you had a candidate who would be reaching into a particular Asian base in one county, and the procedure is established, then you would have an established a Chinese name. You would take that Chinese name and make that applicable to the adjoining county, and if it didn't have the procedures we established, then they would just simply go ahead and use that name anyway. It would not be to anybody's advantage if you had two different names in two different counties. And so.
Other comments, questions to the committee? Move the bill. The motion's move it. This is a due pass to the appropriations. Please call the roll.
Correa?
Aye.
Correa, aye. LaMalfa?
Aye.
LaMalfa, aye. De Leon? Gaines?
Aye.
Gaines, aye. Liu?
Aye.
Liu, aye.
To appropriations, we'll hold the roll open for others to add on.
Thank you very much, Mr. Chair. Thank you.
We'll keep that name.
Thank you. Senator Correa, you have.
Thank you, Mr. Chair and Senators.
Bills up for us here, it looks like. So, do you care to do SB 183 first?
Yes, sir. And if I may, I've got some examples of rejected ballots that are provided to us by the Orange County Register of Voters. And as you see from these, this is my doodle bill, so to speak. And if you notice, some of these ballots were rejected. The first page, or second page, I should say, this individual clearly tried to mark one and then mark the second person. That itself would have canceled that vote, but because he put error GO, the whole ballot was rejected, so none of his votes actually counted. Second page, he wrote in the city of Mission Viejo. That disqualified the whole ballot. Then on the next page, the back where it says left intentionally blank, this person wrote, everybody wants a better life. That disqualified the whole ballot. The next one, I won't say which school district, but it says the worst school district. That disqualified the whole ballot. Then the next one, person putting question marks, who else, question mark, that disqualified that ballot. And, of course, the last ballot, again, other comments in the blank area. Again, the same result. Again, under existing law, a ballot can be rejected just because a voter scribbles on it or makes sure their pen is working. This is essentially, in practice, in my opinion, is unacceptable. This bill will provide that extra marks will no longer render a ballot void, and ballots with personal information will be remade in the same way as damaged ballots.
Move the bill.
This bill is supported by Secretary of State, Common Cause, and has no known opposition. Last one I vote.
Okay, we have a motion on that. Is there witnesses for the bill?
Thank you, Mr. Chair. Members, Rhonda Pascal on behalf of Secretary of State Deborah Bowen in strong support. Again, this bill simply sets up a process whereby ballots that have stray markings on them where the voter's intent is clear, those ballots will still be able to be counted. Be happy to answer any questions. Respectfully urge the committee's support.
Thank you. And any others in support? Okay. Those in opposition to the bill?
Yeah,
okay.
I've got
Seeing none, then go ahead, Mr. Gaines.
Yeah, I just want to take a look at this. got some issues here. It looks like at least the examples that you're citing here. I don't know. I don't know why anybody's writing any comments on a ballot, not just voting. I mean, I think of the elections that I've always voted in or advised my family members for voting. You just fill out the appropriate portion, and if you add comments and things of that nature, I think it's almost an assumption that it's going to be rejected. And so I'm not sure we need to go down this path. And
if I can, Mr. Gaines, I'd like to say that it's interesting that we kind of look at the facts the same way and come to a different conclusion, because my thought is when you're voting, to me, voting is such a sacred right, and many people are so passionate about voting. If you read these comments, I mean, these people are angry. And I didn't put all of the comments just because they are just... You can tell people are angry. They want the system to change, and by golly, I'm going to show you what I think, and they write this stuff down. And common sense, in my opinion, would dictate that just because I write something here, it should not invalidate my vote. I am expressing my freedom of speech. I'm expressing my second right to vote. And if most people knew that just a question mark on there would invalidate the vote, I think people would be shocked. And all what I'm doing, and this is my perspective, is clarifying what I would consider common sense, which is you've clearly identified, you've clearly expressed who you want to vote for, how you want to vote for. The fact that you put a question mark on there because you weren't sure what that meant, is this for Costa Mesa or somebody else, should not invalidate that ballot. And all what I'm doing is just making sure that those votes are not thrown out, giving people with this legislation the added benefit of saying your ballot's going to count despite the fact that you had a little bit too much freedom of speech when you wrote that information down. Ma'am?
If I might, I believe county elections officials very, very frequently, in addition to some of those comments that they might include, I think often voters will think if they need to make a correction on their ballot, as was one of the examples I believe you've been provided, that they need to initial it just as you do when you're writing a check and you make a correction if you made an error on a check. And I think elections officials see that very, very frequently, and I would very, very much like to be able to count those ballots. However, a strict reading of the law, those ballots would be rejected.
And again, on that one where that person initialed the correction, that initialing made the whole ballot invalid. And I think that's clearly against the intent of, common sense here. So we're trying to line up the law with common sense.
I'm just thinking that maybe there's a different approach, maybe an education process through the Secretary of State, just making sure that people are clear. I know that, at least I've been taught, that if you make an error, that's a rejected ballot and you need to return it and get another ballot. But maybe that's not resonating well enough, and maybe there needs to be additional effort. But
and I think that an educational program is one way to go. My thought is, what's the most direct way of fixing this? And my thought is to align the law with common sense, and number two, the most cost effective. It's not going to cost you too much to do this. An education program, I really I don't know what it would cost you.
And I would just say that we make every effort to educate voters, not just on this particular issue, but a number of issues as it relates to elections, including mailing their vote-by-mail ballots on time. And there are still some voters, unfortunately, that don't receive that message. And so, again, to the extent that they are not aware that that's invalidating their ballot, we still believe that where the voter's intent is clear, we'd really like a process and procedure set up to allow those votes to be counted.
All right. Thank you.
Other members with questions or comments? Okay, I'll end with a couple of my own then. That first of all, it is very clear in the instructions: do not mark the ballot inappropriately, or if you have a multiple marking or you want to change what you do have to seek another ballot, one way or the other, because there needs to be integrity to the process for no errors to be made at the registrar's office, at the clerk of the vote, that there's no room for interpretation, because when people start interpreting things, and no offense meant to you or any of your colleagues, but it starts making people really concerned and wondering what's happening. So that's why it has to be pretty ironclad. And in particular, a couple examples on here, there's a phone number written on here. I think you may have redacted part of it here, but and then an initial as well. Now, in the process, we bend over backwards to maintain people's privacy on their ballots. You know, we have on site with people with disabilities, their privacy is to great lengths. We go to maintain that. And so part of the issue here is that there's a privacy portion that can happen on these ballots as well. So, but lastly, it's personal responsibility. Follow the directions. You know, it's do as it says, because the election process should be a little higher than a lot of other things, that people follow the directions. And to go back to a similar argument earlier, that when we're talking about petitions, don't sign petitions that you don't know what they are if you don't trust the person there. Read about it. I wouldn't sign a check, or I wouldn't sign other documents, but I'm getting into the wrong area. But my own argument is that this is a personal responsibility issue. It's a privacy integrity issue, and that's well intended. We all want people's votes to count, but at some point, those voters do have to bear the responsibility of properly handling their ballot as clearly instructed on the ballots, whether you're at a precinct and the people are there to help you, or the mail-in. And so it's just not that tough. And so for me personally, I can't support the intent of the bill as it is right now.
Thank you.
So would you like to close?
Ask for my vote.
Okay, thank you. That be it. The clerk, please call the roll.
Motion is due pass to appropriations. Correa?
Aye.
Correa, aye. Lamalfa?
No.
Lamalfa, no. De Leon? De Leon, aye. Gaines?
No.
Gaines, no. Lou?
Aye.
Lou, aye. 3-2, that measure passes.
Okay, we don't need to hold that open because we have all the members on this. Okay, thank you. All right, congratulations, Senator. Your next one will be doing SB 199.
Thank you.
Okay.
This is an important yet simple measure that helps absentee voters return their ballots no matter where they find themselves in the state on Election Day. Existing law permits voters to return their absentee ballots in person to any polling place within their home county. This bill would also permit voters to return their absentee ballots in person to any polling place within the state. Election officials will then be required to forward those ballots to the proper counties for processing and tabulation. This bill is identical to AB 773 in 2007, written by Mr. Blakesley, which was vetoed by then Governor Schwarzenegger. The governor was concerned with the mandated cost, yet our Appropriations Committee found the cost to be so minimal that the bill was passed out pursuant to Rule 28.8. This bill is supported by Secretary of State, Common Cause, and has no opposition.
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen, also in strong support of this measure. We, as members know, we have an increasing number of voters that are choosing to vote by mail, nearly 50% out of 10.3 million that cast their ballots back in November of 2010. This will make it easier for those folks to actually exercise their right to vote. Happy to answer any questions the committee may have and respectfully urge the committee's support.
We have a motion by Senator Liu. Is there others in support of the bill? Are those anyone in opposition? Okay. Questions from the panel? Okay. All right. Well, I would have one or two myself then. So are we speaking of strictly an election day process here?
Yes.
Okay. So this would be people that have mail-in ballots that need to drop that
correct
anywhere. Okay. I'll come back to the previous one, a personal responsibility issue. Now, counties are big places, and so it would seem to me that people know the deadline, and that my concern lies with partly, too, with the load that we're asking of our county elections offices, in that there's so many more responsibilities they have for verifying and dealing with election day, the mass load of turn-ins. And so it's getting to the point where they're barely, I think, getting their election certified in the, is it 28-day or 30-day timeline, 28-day timeline. And now we're asking them for just one more load, one more straw on the camel's back here of responsibility in transferring these between counties. And so I have great concern, and I have 12 counties in my Senate district, and most of them are very active in talking to me about, don't give me more to do.
Understood.
And so my concern would lie largely in that, but then also personal responsibility. Turn your ballot, either get it into the mail on time or handle it at home in your home county. That's my 2 cents, so please.
Thank you, Senator. And this is another one of those issues that we undertake a great education effort at the Secretary of State's office, trying to get the word out to voters, reminding them that their ballots must be received by the elections official before the polls close on Election Day. So if it's even on the weekend, we're advising them they need to make other arrangements to try to get it to the elections officials' office.
No later than Friday is a safe one, right?
Exactly right. However, having said that, there are undoubtedly at every single election ballots that go uncounted because they are received by the elections officials after Election Day. This it would just provide, and it may not assist all vote-by-mail voters, but if I happen to be someone who lives in Los Angeles County, for example, and had to fly up to Sacramento on Election Day and had forgotten or was unable to drop off my ballot before Election Day, it would allow me to drop it off at a polling place in Sacramento, and they would still have the opportunity to then forward those to the elections official in Los Angeles while they're still in the process of doing the canvass and have that ballot counted. So again, they would still have to, it would have to be in the hands of an elections official before the polls close on Election Day, but it would not have to be in the county in which I reside.
I see your point, but again, for me, and I don't want to sit here and, as a chair, argue this, but it's a responsibility issue, and if you can mail your credit card payment in on time, which has a severe penalty if you don't, something as important as your ballot, you need to figure out how to get that in on time, have a family member be able to drop it in the mail if you left it at home. I think process here, the integrity needs to be upheld very highly, and I'm sure not going to have my 12 county elections clerks after me. So I think I'll also mention that my opposition to the bill is a bipartisan one, since I voted against it in the assembly over there with the Republican author. So because of that, and I hate doing that to my friend Mr. Correa here, but we'll
did it to your other friend, Mr. Blakeslee. So
see, that's fair.
Take it personally.
Okay. Would you like to close, sir?
That's when I vote.
Clerk, please call the roll.
Motion is due. Passed appropriations. Correa?
Aye.
Correa, aye. LaMalfa?
No.
LaMalfa, no. De Leon?
Aye.
De Leon, aye. Gaines?
No.
Gaines, no. Lou?
Aye.
Lou, aye. That measures out. 3-2.
Congratulations. Okay, now let's hear from you on SB 205, Senator Correa.
Thank you very much. This bill, individuals who are paid to register voters or collect petition signatures are, of course, commonly referred to as bounty hunters. Between 1994 and 2010, the Secretary of State's Election Fraud Investigation Unit opened up 960 cases for fraudulent voter registration or for illegal altering of party affiliation on voter reg cards. Out of these, 99 were referred to DAs for prosecution, and 64 resulted in convictions. And as recently as 2010, that's last year, Orange County and other county elected officials received hundreds of complaints from voters who were re-registered with a political party affiliation without their permission. And according to press reports, the companies in charge of these registration drives paid their workers as much as $8 to $10 or more for every completed voter reg card. What this bill does is it prohibits paying voter registration bounty hunters on a per affidavit basis, and the violation would be a misdemeanor. Let me make it clear, you can still pay people to register, folks. You just can't do it on a per-item basis. At least 5 other states, including Colorado, Missouri, Pennsylvania, and Washington and Wisconsin, have similar laws in their books. And if I can state to this committee that all of us are concerned with the integrity of the voter system. And having gone through numerous elections in Orange County, I can tell you that the one area that I've seen voter fraud is in the voter registration process. Over and over again, this is where I see most of the voter fraud, and it's just not me. We have had convictions. I worked very closely with the district attorney, Tony Rakakis, and I can tell you this area is out of control.
Move the bill.
I ask for my vote. It is supported by Secretary of State and the California Association of Clerks and Elected Officials.
Okay, we have a motion. Witness in favor. So.
Thank you, Mr. Chair and members. Rhonda Pascal on behalf of Secretary of State Deborah Bowen, again in strong support, as we believe that this has the potential to decrease fraudulent voter registration practices. Happy to answer any questions. Respectfully urge the committee's support.
Others in support.
Good afternoon, Mr. Chair, members of the committee. Dean Logan, Los Angeles County Registrar, Recorder County Clerk, on behalf of the California Association of Clerks and Elections Officials, we support this bill as well.
Thank you. Others in support? Those in opposition?
I'm Richard Wenger with the Coalition for Free and Open Elections. I'm not really so interested in stopping this bill as pleading for an amendment. I suspect the people who thought of this bill didn't think about the fact that Prop 14 changed the way the qualified minor parties stay in the ballot. It's not possible anymore for them to stay in the ballot if they get 2% of the vote for any statewide race in a gubernatorial year. Instead, they must have their registration up to 1% of the last gubernatorial vote, which right now is 103,000. Minor parties have been taking a terrible beating in the state recently. In the last year, not only has it become much more difficult for a party to remain ballot qualified, the petition in lieu of the filing fee for minor party members has skyrocketed. Minor party candidates are going to be excluded from the November ballot, and even write-ins won't be counted in November anymore. Now, on top of this, this bill threatens to take away the only feasible way for a minor party to get its registration up to 103,000. I passed out a piece of literature to your offices. I don't know if you each got a chance to see it, but all 6 of the minor parties that have got on the ballot since 1950 have used the registration method, and there was a lot of volunteer work, but they all had to pay people, and it's a tough job to go out in the street and talk a stranger into registering into a party that person has probably never even heard of. It's very hard work, and you just have to pay people per registration card. But the thing is, it doesn't have to be that way. If the bill could be amended to decouple the way parties stay in the ballot or get on the ballot from how many voter registrations they have, then that would solve the problem. There's plenty of other ways to do it. I'm an expert in this area of the law, and I'd love to talk to the author or the Secretary of State about a way so that the number of registered voters in a party is no longer keyed to whether it's a ballot qualified party. There's no longer any connection now between how many ballot qualified parties there are and how many candidates are on the ballot. Under Prop 14, except for President, everybody has an easy time, if they can afford the filing fee, getting in the primary ballot. So whether that person's party is qualified or not is immaterial to whether the ballot gets crowded. So it's time to rethink party recognition, and I hope this bill could be amended to do that.
Okay, others opposed?
My name is Dave Kadlacek, and this time I'll speak in my hat as a co-chair of the Alameda County Peace and Freedom Party and a participant in its state central committees, elections, committee. As Mr. Winger mentioned, the minor parties, including Peace and Freedom, are under threat of losing their ballot status due to Prop 14. Peace and Freedom is planning a paid registration drive, a registration drive of which a component would probably be a paid registration drive in order to keep our ballot status. And if this bill were passed, it would make it virtually impossible to have a paid registration drive as a component of this. When there was some discussion within Peace and Freedom's elections committee about this, our most recent past state chair, Kevin Aiken, pointed out that during the time Peace and Freedom first qualified for the ballot, there was before the current registration system in 1967 and 68. At that time, registrations had to be done through deputy registrars who were appointed by the county and registered people on a nonpartisan basis, and those deputy registrars were paid per registration, per piece. And he was suggesting maybe it will be a good idea to go back to that system that basically does away with any possibilities of fraud and seemed to work then, unlike similar systems in other states. I'm told, I'm not sure if it's true, that the Federal Motor Voter Act actually allows that as if it's combined with same-day registration at the polling places, but that if there isn't same-day registration at the polling places, then you're required to have mail-in forms like we do currently in California. That was it.
Okay, thank you. Any other opposition? All right, questions from senators? Mr. Gaines.
Yeah, this sounds very similar to the previous bill that we heard, and I, again, have challenges with it. And I can speak, I guess, from a party perspective. I know the Republican Party has been very vigilant about making sure that if we're paying per registrant for voter reg, that those are legitimate. And we don't work with the folks that are giving us fraudulent voter registration forms. And so I think that a lot of this can be kind of self-monitored in my mind. I think Mr. Richard Winger raises some interesting issues also. I think that's true about Prop 14 in terms of the lack of representation of smaller parties, and I think all parties should be represented. I'm not quite sure what the fix is with that, but I think both the Democrats and Republicans felt that was an issue and a problem that was not properly addressed in Prop 14. But getting back to this piece of legislation, I just feel that can be self-regulated, and therefore I'm in opposition.
Thank you.
Okay, any other questions from our members? I would go lastly then with what really are you trying to do differently than the Corbett bill?
Well, mine deals with voter registration, and Ms. Corbett deals with signature gathering. It really is the main difference. And
so they're not overlapping on both registration and signature gathering?
No. But I did make the comment earlier that it has been my experience in Orange County that when you have signature gathering effort, those people gathering signatures are also doing voter registration at the same time. And to Mr. Gaines' comment about which party uses which, you open the door, but I'm not going to go through that door because I want to get into that debate. But I've noticed over the years that when you do pay on a per head basis, the incentive for voter fraud is tremendous. Okay, and in Orange County we've had numerous voter fraud cases. I mean, I've lived through these. In the one area you see voter fraud coming up over and over again is paying on a per item for voter registration. Okay. And go ahead. Go ahead.
Okay, but are those being dealt with? I mean, isn't there
to the best extent
a path in the event that a law is broken that those people are prosecuted?
To the best extent, and not all of them are being prosecuted. Go ahead.
And if I could just say, there are some cases that are referred to the Secretary of State's office. Not every case that comes to the attention of a county elections official even gets referred to the Secretary of State's office. In some cases, they may have staff there that investigates the particular allegations, and they may work with their local district attorney. And everything that comes to the Secretary of State's office is investigated, but it is difficult at times in these types of situations to gather the evidence necessary to then for our staff to feel confident in even then referring those cases to the DA's office for prosecution. And ultimately, it's up to the DA's office and whether or not they decide to pursue prosecution or not. Our office does not have the authority to do that, nor do the elections officials. They do have to rely on law enforcement to pursue that.
And Mr. Gaines,
if it were chronic enough, I mean, if it was a big enough case, don't you think that the local DA would step in and fight that?
The local DA has stepped in to fight it in our county. And let me say that personal responsibility, big, very important. But I will tell you that in this situation, we have an incentive system to register people that's rigged to give all the incentives to register as many people as you can, as the quickest time as possible, to make as much money as you want, based on how many people. And like everything else in our society, we're an open society. We're not a police state. People go out there and take advantage of the system. I've walked door to door and I've asked people, why haven't you voted? Well, I'm not a citizen, and I did not sign up. And you find people do not vote because they know they're not supposed to, but somebody signed them up. And to hire a major police force, an investigative force, to go out and enforce the law is almost, contrary to what, to getting to the end of the solution. So what you want to do is pull back and take away the incentive to create voter fraud here. Okay. And this is the one area.
I'm going back to Corbett's legislation, Senator Corbett's, but there was some testimony that was given that there was not a difference in the rate of fraud for something that's paid on a per signature, or in this case, per registration basis versus hourly. And so I'm not quite sure that there's, from what I've heard today.
I heard the numbers that were given by the opposition, and I think I saw some other numbers that would say the rate of voter fraud is much higher than the numbers from the opposition gave.
And if I could just add, I've not seen the report that the gentleman was referring to, so our staff has not had an opportunity to review that. Okay. But just speaking from the experience of our election fraud investigation unit, they do see certainly an increase in the cases where you are paying per signature or you are paying per affidavit, because it does raise the incentive for folks to mislead.
What's the interest of the party paying to pay for a phony registration? I mean, I don't see the incentive there. Why would you pay good money for a bad registration?
I think there's a lot of incentives there, but I would sum it up in the following way, which is there are some, and to the best of my recollection, in our area, those people that are doing this type of per head voter registration, and you find irregularities, they keep coming back to the county and they keep getting rehired.
Okay. Well.
Okay. You tell me. I mean, I'm very, respectful of the law when it comes to elections. Mm-hmm. I don't even go close to that line, and so, I would never hire anybody to register people on a per item basis. And like many others here, I've registered a lot of folks on my own. Mm-hmm. Democrats, Republicans, and third parties. But what the incentive is?
I can only speak, I guess, from my own experience at the local level. And when we got a bad apple, we didn't work with that individual any longer. And I know the state's doing the same thing. I can't speak to your district, really.
Yeah, I hear you. Yeah. But may I conclude at the right time?
Right, thank you.
Thank you, Mr. Gaines.
Okay, any others by our panel? Okay. I guess I would just add, too, it comes back to let's work it from the enforcement side, making it a very unattractive prospect to get caught doing this. That if the prosecution, if people aren't scared enough to do this, because I agree with Mr. Gaines' assessment of it, that I don't want to pay for bad registrations if I'm helping to run a program like this. I mean, why do it? If I'm shipping rice, I'm paying on a per hundredweight basis, not on truckloads, or somebody can start shipping light truckloads on me. So per piece works out pretty well. And I know in the process people make photocopies, keep track of all this. There's a prosecutable angle there from going back and checking out this fraud, like who was the person that sought and received or even forged signatures on this. Go right direct back to the source and light them up. I'd join you with that effort. So I think we're kind of barking up the wrong tree here with we're respectfully, sir, where this bill is going, and as well as the Corbett bill earlier. Let's get after the bad actors and not a process that is leaving out people that are at a grassroots level or the smaller parties as well. Prop 14 was a tragedy for having everybody represented for the small parties, and being a Republican, I'm wondering when we're going to be a small party around here one of these days as things are going in the state of California. But the joking aside, that's my 2 cents on there. So if you'd care to do a complete close.
Thank you. Yes, I will. Thank you, Mr. Chair. First of all, I'll be more than happy to join you in any legislation to enhance the penalties. This is already a felony. We can try to figure out another enhancement somewhere to make this a greater crime. In terms of your comments about Prop 14, Prop 14 was passed by the vote of the people, the initiative process, and your concerns of the Republican Party becoming a minority party. I think the Democratic Party has the same issue, because ultimately it's the decline to states that are the fastest growing party in the state of California. And to me, that is the will of the people, and I respect it. And Prop 14 was passed by the people, and I respect that too. But I understand that this bill does not deal with filing fee, does not deal with Prop 14, it does not deal with party recognition. It does not say you can't have a voter registration drive. It does not say you can't pay people to register voters. It just says you cannot pay to register voters on a per card basis. It's a very important bill, and again, trying to take the incentive out of this fraudulent process that's caused so many people so much harm. I ask for an aye vote.
Okay, thank you. The clerk, please call the roll.
Motion is due pass to appropriations. Correa? Aye. Correa, aye. Lamalfa?
No.
Lamalfa, no. De Leon?
Aye.
De Leon, aye. Gaines?
No.
Gaines, no. Lou?
Aye.
Lou, aye. That measure passes 3-2.
That bill passes. So, Senator, congratulations.
Mr. Chair, I look forward to earning at least one of the votes.
I'll hand the gavel back. We have votes that need to be added on from previous bills, so I'll hand the gavel back to you, sir.
Thank you, members. We have a few items that are still on call. Madam Secretary, if you call out item number 1, Senate Bill 88, call the absent members.
De Leon?
Who was that 88 by?
Yee.
Aye.
Yee. Motion is due pass to appropriations.
Item number 2, Senate Bill 106 by Mr. Blakesley.
Motion is due pass to appropriations. De Leon?
No.
De Leon, no. 4-0.
Item number 3, that's Senate Bill 141, Price.
Motion is due pass amended to appropriations. De Leon?
Aye.
De Leon, aye. That measure passes.
Item number 4, Senate Bill 168 by Corbett.
Motion is due pass to public safety. De Leon?
Aye.
De Leon, aye. That measure is out.
Item number 5, Senate Bill 180.
We're done.
We're done. Seeing no further business for this hearing is now adjourned. Thank you, members.